So, this is Kyra Fontenot, the Fontenot Firm, and I want to spend a little bit of time explaining to you what Title VII is and why you need to understand that in terms of your workplace. Title VII of the Civil Rights Act of 1964 is a law that protects employees in the workplace. Employees in the workplace are supposed to be free from discrimination, and Title VII is one of the main laws that protects employees from discrimination. Now, employees in this case are people who work for companies that are large, have more than 15 employees. So if you work for a company that is smaller than 15 employees, Title VII does not apply. But if you do work for a company that has more than 15 or more employees, Title VII protects you against discrimination on the basis of race, sex, national origin, religion, pregnancy, and color, which is kind of similar to national origin and can also be similar to race. And there are other statutes that cover other areas of law, but for Title VII, race, sex, national origin, religion, and color. Now, Title VII also has retaliation provisions, and retaliation is when your company discriminates against you because you complained about discrimination on the basis of race, sex, national origin, your pregnancy, or your religion. If you did not complain based on one of those kinds of discrimination, Title VII does not apply to you. Title VII also protects you if you participate in an investigation of someone else's discrimination on the basis of race, sex, national origin, color, religion, or pregnancy. Now, what does that mean? If you need to testify in a case because of you're witnessing someone else's discrimination, the company is not allowed to take action against you because you participated and testified truthfully. And if you are associated with a person who has made a claim of discrimination based on race, sex, national origin, color, religion, or pregnancy, you can also be protected. So let's say you and a spouse all work at the same company and your spouse is complaining of race or sex discrimination. And because your spouse is complaining, they fire you. That would be discrimination based on your association with a person. Those are all covered bases for employees to seek compensation if they are harmed by an adverse employment action on the basis of race, sex, national origin, color, religion, or pregnancy. There are other ways that you can show that you have been discriminated against under Title VII. And some of those ways have to do with like broad policies that show that there is a bias against people of color or who are women or who have a different national origin. And that could be where there is a policy that is not explicitly about race or sex or national origin, but has an impact on people who are of that race or sex or national origin. So, for example, say the company has a testing scheme that disadvantages women. That can be what's called a disparate impact claim. The vast majority of cases are not disparate impact claims. Those are cases where there's just a neutral policy that just has a bad impact on a protected class of people. Most cases are disparate treatment claims, and that means that one employee who is of one protected class is being treated differently than people of a different protected class, so who are not in the same protected class as the employee who is feeling the effects. What does that mean? Normally, that would mean that you are a person who is in one protected class. Let's say you're a woman, And because you are a woman, you are not allowed to have the supervisor position. Women are treated differently. You, as a woman, are being treated differently than a man. And the way you would prove that is you would look at your qualifications as it related to the job and the other person's qualifications. And if you said, well, I met all the qualifications and I did not receive the job, but here's this person who's a man who met none of the qualifications and he did get the job, that would be evidence of discrimination. There's another common way that we prove discrimination in the workplace, and that is under a harassment theory. The harassment theory talks about severe or pervasive conduct that is so bad that it alters the terms and conditions of your employment. Harassing conduct is not simple discipline or putting you on a performance improvement plan. Harassing conduct usually has to do with conduct that is directed at your protected status. So let's say you're a person of color and you find racial epithets or racial slurs written on your workstation. You find a noose on your workstation. People are calling you a racial word instead of your name. They say things or do things or touch you in ways that are inappropriate. So say, for example, you're a woman in the workplace and your boss does not give you overtime unless you will agree to go out on a date. That is harassing conduct. If your boss keeps talking to you in sexual terms over and over and over again, that is harassing conduct. But generally what we're looking for is something that is either very severe or that happens so frequently that you cannot do your job the way you should. Not something that happened one time, not something that wasn't very severe, but something so very frequent that it actually alters the way you have to do your job. Now, when you have been the victim of harassing conduct, it is very important that you report that conduct. And the company should have a policy about how you report harassing conduct. Now, do you need to report it to HR? Should you report it to your manager? Should you report it to a designated person in the office? You should look to your handbook to determine where it is that you're supposed to report it and follow that procedure to its logical conclusion so that you can preserve your claims. So we've talked to you just a little bit about what Title VII is. There are other statutes that protect people in the workplace for discrimination on other bases, but Title VII is the main one that covers race and sex discrimination. One important note about Title VII. Title VII also covers people who are in the LGBTQIA community. It used to be that Title VII was not necessarily recognized as something that covered people who were gay or lesbian if they received discrimination in the workplace based on their sexual identity. If you believe that that is a factor, you are now covered because the Supreme Court of the United States has said that people who are in the LGBTQIA community also have protections under Title VII for discrimination, retaliation, and harassment in the workplace. So that's very important to make sure that everyone understands that you cannot discriminate against a person based on their sexual identity. So if you have any questions, you can always get in touch with us at kyrafontenot.com or call us in the office, but we would love to talk to you about how Title VII might apply to you.